I'm Doug Ginsburg, and I'm here today with Judge Vaughn R. Walker of the Federal District Court in San Francisco. Judge Walker served on that court for 21 years and only recently retired from the court. He's had an extraordinary career in antitrust, first in law practice and then in the court. Going forward, no doubt we'll have more of that. But I want to ask you, Judge Walker, to start at the beginning. How did you first get interested in and involved in antitrust litigation?
It probably goes back to childhood. My father was a businessman, and I would go with him on business trips. He had business publications around the house, and I recall in particular an article in Forbes magazine, reading when I was 11 or 12 years old, an article about truck trailers. And when we were on one of these trips, I was counting the number of Fruhoff and Dorsey and other truck trailers. It was, I think, my first effort at calculating market shares. But with that experience, it seemed quite natural to get interested into economics, get interested in business. And when I went to college, majored in economics, studied a little industrial organization, and I think the interest in antitrust just followed naturally from those influences.
Mm-hmm. Well, I'm going to want to return to the influence of economics in your work, in your later work. So I'm glad you mentioned it at the outset. I wasn't aware that that was your major field of study. So what about antitrust law? You studied that as well?
Yes. I did my first year of law school at the University of Chicago after having studied economics at Berkeley. And the reason I chose Chicago was because in those days that was the only school that was notable for law and economics. And I thought, after I decided not to become a professional economist, that I didn't want to leave economics entirely behind, and so I went to Chicago, but found that the first year curriculum in law school at the University of Chicago had very little law and economics in it. So I then transferred to Stanford, where lo and behold, I found as a teacher Richard A. Posner teaching a regulated industries seminar that I took. This was his first year of teaching. He was fresh off a law clerkship with Phil Ellman on the Federal Trade Commission. And in addition to Posner, there was Bill Baxter, Ken Scott, and others who taught a good deal of economics in the law subjects that they taught. So as it turned out, I went to Chicago thinking I would find law and economics, transferred to Stanford and found law and economics.
Well, and some of the really important influences on the field as well, in Baxter and Posner and Scott. So did you go directly then from law school into an antitrust practice?
No, I did a clerkship for a couple of years, or close to a couple of years. The clerkship was with Judge Kelleher in Los Angeles, who's a federal district judge who is still happily sitting. He's 98 years old and has been a great personal friend and influence with me. I don't remember too many antitrust cases that we had when I was a law clerk. I do remember one argument in particular in which the lions of the antitrust bar on the West Coast were present. And I thought, golly, this was a very stimulating argument, and that obviously further piqued my interest in antitrust and this whole area of law and economics.
So you became an associate in a law firm?
Yes, I went to San Francisco, became an associate at a firm then known as Pillsbury, Madison, and Sutro. Was hired to work on the Western liquid asphalt cases, which were a series of cases that arose out of the Interstate Highway project, in which it was alleged by various Western states that the major asphalt producers had engaged in horizontal price fixing of asphalt that was used in the construction of the highway system. Needless to say, the volume of documents in that litigation was overwhelming, and it was an army of associates and paralegals working on those cases. And suddenly, the realities of antitrust litigation began to dawn on me.
By the way, the asphalt industry seems to have been a continual source of antitrust litigation. Judge Posner wrote an opinion on the matter just a couple of years ago. Any idea from your experience what it is about the economics of that industry that plagues it?
I don't know that it's so much the economics of that industry so much as it is the bidding process to government agencies that almost invites the kind of collaboration that one observes in that business. Several years ago, in an altogether different context, some lawyers presented to me a transcript of a meeting that they held in which they were bidding on the right to represent plaintiffs in securities litigation. And for some reason or other, they thought that this should be recorded. It was recorded. A transcript was prepared. And the discussion at that meeting bore a very great resemblance to the kind of discussion that you hear among asphalt contractors when they're bidding on a paving contract with some state agency.
And were you able to avoid the pitfalls that the agencies fall into?
Well, I hope so. I made every effort to do so.
I think you're credited with by some with having originated the idea of auctioning off, as it were, or taking bids for the right to represent.
Well, that's probably correct. I must say it was not with a lot of forethought. The case came up about 3 months after I was on the bench, and the lawyers in that case were fighting with one another over the right to represent the class. And the battle was being fought on these highly subjective terms. And it finally, after listening to this dispute for some time, dawned on me that perhaps some economic criteria ought to come into the picture. And I said, well, why don't you just present a proposal, a bid on this arrangement? That suggestion brought silence to the courtroom. And as a matter of fact, what followed thereafter was a joint proposal by all of the lawyers. And that really got my dander up, and I finally decided, well, we're going to have a competitive bidding for this project, and that's how it began.
And I gather that's the norm now in large class actions.
I don't know that it is the norm in all cases. This was a securities case. And securities cases are particularly well suited because so much information is known at the outset of a securities case, whereas in most cases, antitrust being one of them, the plaintiffs are often poorly informed about many of the facts of the case. But the Private Securities Litigation Reform Act of 1996 introduced a new way, the lead plaintiff or the most adequate plaintiff criterion for the selection of the lead plaintiff. But what has happened in that field is that some of the larger institutional investors have engaged in a competitive selection process for lead counsel. So the focus has shifted away from the court doing the managing of the bidding process to the private parties, which is probably a better arrangement.
Well, after asphalt, what were some of the other cases in which you participated?
I spent a great deal of time in a series of cases involving a whole variety of commodities. Beef, oranges, various commodities, because the firm that I was with represented Safeway stores. And there was a very successful case in the early 70s involving the beef industry. And that spawned a series of copycat cases in a whole host of different commodities, in which it was alleged that the retail food chains had conspired to drive down the prices paid to wholesalers, and in turn, they drove down the prices paid to farmers, ranchers, growers. Much of that litigation, at least in the federal courts, was essentially negated when the Illinois brick decision was handed down in whatever year in the 70s it was handed down in.
Mm-hmm. Mm-hmm. Well, when you went on the bench, were you known as an antitrust practitioner?
I don't know whether that's true or not, because what happened, and I think it's quite a natural thing to happen in one's law practice, one starts in one field and you then get led by client relationships or other circumstances into other fields. Mm-hmm. And most of the practice that I had in the 10 years or so before going on the bench in 1990 was probably not antitrust work. It was a whole variety of different areas of law and a whole variety of different kinds of clients. So while I continued to do some antitrust work, probably I was much more of a general litigator when I went onto the bench than an antitrust specialist.
And how did it come to pass that you were nominated?
I had decided to seek something other than private practice. I was on a body called the California Law Revision Commission at the time, a gubernatorial appointment. So I knew the governor, Governor Duke Majan. The position of Corporations Commissioner of California became available. I called the governor's appointment secretary, told him I was interested in it. That led to an interview with the governor, spent a day in Sacramento, and I thought things were going well. Did not, in fact, get the job. But the word got around to some people who were working with Senator Pete Wilson that I had expressed an interest in this position. And a few weeks later, received a call from one of these individuals who said, I understand you're looking for a job. I said, well, yes. He said, well, how would you like to be a federal judge? So as it turns out, I aimed for one thing and got a much better job than I had initially aimed to get.
Certainly one that lasted longer.
Yes. Corporations commissioners generally don't stay in office 21 years.
No. But judges often do stay on forever, serve out their term, which is a life term.
A life sentence.
A life sentence. And you've elected to try something else next. Will it involve more antitrust?
Probably, at least I hope so. I continue to think antitrust is as interesting a field of law as there is. It's a field of law that deals with large issues. They're important issues economically. They're important issues in terms of the welfare of a community, perhaps the entire nation. The common law character of most antitrust law, I think, gives it a vitality and an interest that isn't true of many other fields of law that are much more statute bound. So there's an opportunity for lawyers and judges to use the tools and intellectual gifts of law in a more creative way than is true of most areas of law.
Well, let's take a look at some of the cases that you've handled as a judge then, where you've had this opportunity to be creative and to shape the law. Among the better-known cases is the litigation involving the publishers of the major newspapers in San Francisco. How did that case come about?
I've often said that there was no case that I presided over as a judge that was more fun than that case. That had great interest not only because of the antitrust issues, which were themselves quite interesting, but there was a great deal of local color. It arose out of San Francisco, which is a rather colorful town in many ways, with a colorful history. The lawyers were some of the outstanding antitrust trial lawyers. Joe Aliotto on the plaintiff's side, Tom Rush, who's now on the Federal Trade Commission, Dan Wall on the defense side, Gary Halling on the defense side. It involved, in addition to the local color, the color of the newspaper industry, which is quite remarkable. So all of these influences came together, and it essentially represented, I think, the official recognition that the joint operating agreement approach to trying to save newspapers was not a viable approach. And so there were a lot of things that came together in that particular piece of litigation that made it, from a judge's point of view, remarkably fun and interesting.
And I gather it pitted some of the major families in the city.
It did.
Against each other as well.
The DeYoung family, which was the founding family of the San Francisco Chronicle, and the Hearst family, obviously the owners of the Examiner, the afternoon newspaper, and all of the Hearst newspapers around the country.
Now, the Department of Justice got into this somehow.
It did.
What happened there?
Well, the Department of Justice eventually approved the dissolution of the joint operating agreement under which the two papers had operated since, I believe it was 1964 or 1966. And that joint operating agreement provided for a 50-50 split of the profits. Because the morning paper was much the stronger paper in terms of circulation and advertising appeal, that 50-50 profit split was disadvantageous to the morning paper. And Hearst, by reason of an option to extend the agreement, had some leverage in the transaction. But eventually the parties agreed to a dissolution proposal, applied to the department for permission to dissolve the joint operating agreement. And it seemed to me the department took an unduly long period of time in consideration of that proposal, which had, I thought, pretty compelling reasons why it should be acted upon. And it did appear as if some of the influences on the length of time that the department was taking in approving this transaction may have been as a result of some political considerations that were going on, which gave the case an even further point of interest.
Local politics in San Francisco?
Basically. The department refused to approve the dissolution until Hearst made quite a remarkable deal with a local group to take the Examiner banner, trademark, and certain of its assets, which was the Hearst paper, and a subsidy of $65 million. It's not often that you sell an asset and also give the buyer a great deal of money to take it off your hands. It was kind of a put. And until that put, until that put arrangement was made, the department, I thought, dragged its feet in approving the dissolution. And it so happened that the group to which the the Examiner asset was transferred, plus the $65 million subsidy, was a group that was affiliated with some of the local political interests.
Well, presumably the department was proceeding, or saying it was proceeding, in the hope of preserving a second newspaper.
That's correct.
And the facts seem consistent with either possibility, do they not?
Well, it did preserve a local paper of sorts, but it was certainly not a paper that was one that bore any resemblance to a general circulation daily newspaper, and was truly not a competitor in the true sense of the word. Now, subsequently, there has been a development in which a subsequent group on its own has picked up those assets and is producing a free distribution newspaper that bears the Examiner trademark. Whether that truly is a second newspaper in the sense that the Newspaper Preservation Act had in mind, I think is doubtful, but nonetheless there is at least some semblance of newspaper competition that remains.
Mm-hmm. Pardon me, you were quite hard on the Department of Justice in your published opinion, which grabbed my attention as I went back to it.
Well, Joel Klein has told me that he thought I was a little hard on the department.
Suggesting cronyism was afoot. Well, I suppose the most closely watched and memorable case on a larger scale, antitrust case that you handled, was the Oracle acquisition, proposed acquisition of PeopleSoft, which the department sought to prevent. And the outcome was favorable to the transaction. You rejected the government's position in that case. It strikes me as an extraordinary opinion because of its learning and its use of economic methods throughout. Is that the capstone of your economics career thus far?
Well, it may be. I'm not sure that one thinks about these cases quite in those terms. It was an extremely well-tried case with extremely able lawyers on both sides. The department did an excellent job in presenting the government's case. The experts were outstanding. Kenneth L. Zinga for the government, and equally well-qualified economic experts on the defense side. The issues were highly interesting, involving relatively new and fairly technical products. Basically, both companies were engaged in the production of highly sophisticated database programs. And it involved the issues that surround those kinds of high technology products with their peculiar characteristics. What I think convinced me that the government's position was should not prevail in the case was I didn't think that the government had overcome the burden of proof that it bore in establishing that the products at issue were a sufficiently defined market that would permit the kinds of findings that were necessary in order for the government to prevail. And it was extremely difficult for the government to articulate a meaningful definition of what this market was. The alleged market was high-function financial management software and human relations software. The problem was that these products were sold in pillars that included many other products, and it was extremely difficult to disaggregate the prices charged for any one element of these pillars. And basically the government's market definition came down to a kind of I know it when I see it kind of theory, and I didn't feel that that was sufficient to carry the government's burden of proof.
Just to be clear, in this context, is a pillar the same thing as a package?
A pillar would be a particular kind of product. For example, you could have a financial management pillar, you could have a human relations pillar, you could have a customer relations pillar, and so forth.
And could the customer buy one program from that pillar, or do they have to buy the whole thing?
It could buy various segments of this and put it together in a total package. And if memory serves correctly, then it was the total package that was negotiated, and the price was attached to the entire package. So it was extremely difficult to segregate what was charged for each particular item. And because the financial management and human relations software was often sold together with a lot of other products, and the price that the transaction closed at embraced the entire package, making it very difficult to define what the market was for the particular pillars that were involved in the case.
Your opinion surveyed the evidence and the witness testimony in quite great detail, and you found some of the testimony not credible, other portions of it just simply not adequate to make the point for which it was being offered. As I recall, Ken Elzinga on the government side was facing Jerry Hausman.
That's
and
correct.
David Teese, and yet another prominent economist, his name escapes me just now. Did you think that the government did as good a job as it could in presenting its case?
I think the government did an excellent job given what it had to work with. The case was very ably tried on the government's part, and of course very ably tried on the defense side as well. So in no way would the result suggest an inadequate presentation by the government.
Did the government appeal that judgment?
It did not. The government did not appeal, and the decision was followed by the European Union competition authorities, which had held off in challenging the merger pending the outcome of this particular case.
One of the interesting features of the case is the degree of explicit economic work in the opinion, and of course in the trial, and the facility with which you laid it out and explained it, including several graphs in the opinion, citations to economics literature, and so on. Is this a case that any federal district judge anywhere could have tried with equal facility, or is this the sort of case that presents a real challenge to someone who doesn't have an economics training?
I think federal district judges are pretty good when they get down to working on cases. We have a lot of default rules that come into play, and the ultimate default rule in this case, notwithstanding the economics that's in the opinion, the graphs and so forth, the default rule was what decided the case, and that default rule is that the government bears the burden of proof in a case like this, and if it can't present enough evidence to tip the scales in its favor, then it loses. So I think the case could have been tried by any reasonably able federal district judge, and perhaps not all federal district judges would have lathered the opinion with the economics that I did, but I thought it was, one, interesting and helpful, and the lawyers had presented the raw material with which I could do that.
Over the last 30 or so years, when as economics has been incorporated more and more centrally into the antitrust analysis that's done by the agencies and by counsel, there have arisen a number of different approaches to dealing with the problem of a general jurisdiction court reviewing either enforcement decisions or agency decisions of this sort. Specialized tribunals in some countries, an economist on the Cour de Cassation who's not a lawyer, and what we seem to have here, and that is just a hope that judges will take an interest, and there are offerings of courses in economics for judges, for those who are interested. Do you think that's a worthwhile approach?
Oh, absolutely, because economics comes into legal analysis in a whole variety of different fields, not simply antitrust. And so the more judges have available the tools with which to deal with economic questions, the better able they are to deal with these questions of fact or law that are presented. In terms of the other aspect of your question, whether we should move toward specialist courts, I think that's a much more problematic question, in that there's a great advantage, I think, in having generalist judges and generalist courts deal even with the most sophisticated questions. And it applies not just in antitrust, it applies in the intellectual property field, patents, and other questions as well. Ultimately, we are deciding these questions on criteria that have to be explained generally to the public. And the presentation of cases to a judge who may not be a technical individual, may not have technical training or even particularly technical interests, forces the parties to present the cases in ways that can be understood by a generalist. And then a generalist judge, I think, is better able to explain his or her decision to a generalist audience. So I'm not an advocate of highly specialized tribunals to decide even these very complicated, sometimes very technical issues.
In the, I guess, 35 years perhaps since you were first doing asphalt cases to the recent Oracle PeopleSoft litigation, how has the practice changed, do you think, for the antitrust litigators?
I think it's gotten better. I know that may be a minority point of view. When I talk to lawyers, and of course they're closer to the actual practice than am I, but observing how law is practiced from the vantage point of the bench over the past 21 years, it strikes me that the cases are better presented now than they were when I first went on the bench, and better presented then even than when I first started practicing. That the lawyers tend to be much more focused on what a court needs, what perhaps a jury needs to understand these issues, and are much better able to present these issues than was true in the past. So I think there's been a great deal of learning on the part of the bar. That's been very, very helpful. One antitrust case that you haven't mentioned was a trial of a consumer case, I believe in 2007. I'm told that it was the first time in the Northern District of California, which, as you know, has seen a lot of antitrust activity over the years. It's the first consumer antitrust case that actually went to a jury trial. And the issues were not terribly complicated by antitrust standards. The lawyers were very able, and they honed the case down to those essential issues and were able to put the case to trial from beginning to end in 2 weeks, and did an excellent job. That is, I think, it's a tribute to those particular lawyers, but it's a tribute to the skills that I think the bar has developed to try what are basically pretty complicated issues in a way that is succinct enough to present to a jury so that a jury can present a reasoned decision.
Has that been more true of the antitrust bar than the general bar?
I'm not sure that it's more true of the antitrust bar, but I think it definitely is true of the antitrust bar. In some of the intellectual property fields, I think the lawyers are still struggling with some of these issues. But it does seem to me that the bar has gotten much better at learning how to deal with these kinds of questions and to distill them in a way that a generalist judge or even a jury can understand.
You were preceded in the Northern District by William Schwarzer, who taught us all a great deal about the efficient handling of antitrust litigation. And I was impressed to note in your oracle opinion the way in which you made findings that would be useful in the event that there was a successful appeal. So has case management, antitrust case management in particular, been something that is also, you think, improved over the time of your experience?
I believe so, and much of the credit for that does belong to Judge Schwarzer, who made tremendous contributions in this regard to the judiciary. He was a great, dear personal friend of mine and very helpful to me from the very beginning of my law practice. And of course, a highly valued and esteemed colleague for the last 21 years on the bench. I do think, in addition to the bar getting better at learning how to manage these cases, the bench has also done a lot of learning. And you're absolutely right. When you're sitting as a district judge, you have your eye on that Court of Appeals, and you want to make those findings so that the Court of Appeals can do its job and review your work and decide whether or not you've addressed the issues, and if you have addressed them, that you've done so either correctly or incorrectly.
It's been lamented in many quarters that there are very few actual trials now in federal district courts, and that federal practice has become a summary judgment practice. Well, you've been talking about some extended, important cases that have gone to trial. Has there been nonetheless a tendency towards resolution by summary judgment in your court and experience?
There has been. And motions to dismiss for a whole variety of reasons that go quite beyond what we can discuss here today. There is a kind of an unfortunate tendency that accompanies that. Well, let me back up one step. I think there are reasons why this has developed. And the principal reason is because of the huge number of cases that come through the system. There's no way in the world that anything other than a very, very small percentage of them could be tried. And so techniques have had to be developed to decide those cases in a way that allows the system to proceed, and that includes, among others, summary judgments. That creates something of an inertia on the part of lawyers and judges that suggests, well, this is the track, this is the usual track. And so we kind of consider that this case is going to go down that summary judgment track rather than go down the trial track. And I think it's helpful for judges and lawyers every once in a while to pull back a little bit and think more about how this case can be tried. And it would be helpful, I think, if we were on both sides of the bar bench and bar to do that.
Are you confident about the direction of causation between the efficient handling of cases and the large number? That is to say, could it not be that the court's becoming more efficient, invite more filings?
Could very well be, I suppose. But there certainly are more. There are more filings, and there are more filings of a kind that invite summary disposition. But of course, our inventory of cases are largely the product of what Congress does.
Right. Now, of course, in the antitrust area, as you said, it's much more of a common law.
Yes, which is one of the refreshing aspects of antitrust.
Well, I shouldn't let you go without asking for what you would tell someone newly entering the practice, young lawyers who are interested in antitrust, about how they might best proceed.
It seems to me, Doug, that the best antitrust lawyers are the best lawyers. The best antitrust trial lawyers are the best trial lawyers. The skills, the gifts of learning how to present a case extends over the entire reach of cases that we have. It is to be sure that there are certain issues that are unique to any one field of law, including antitrust. But the basic skills, the basic tools that you need to present an antitrust case are fundamentally the same as any other kind of a case. And so the best advice I think an aspiring antitrust litigator could receive is to focus on those trial skills, those skills of rhetoric, close reading, common sense that come in handy no matter what the field of law is.
So, general practice, generalist judges, and not to worry about specialization either in the bench or the bar.
I wouldn't worry too much about specialization.
Mm-hmm.
The specialization will come, and the remarkable thing about our profession is you will be drawn to those areas of law that interest you.
Well, you came in with an interest in economics, and were drawn to antitrust, understandably. You've made a tremendous mark in the field and used your economics to obvious advantage. But you're still a little bit shy of telling people to study economics in order to do this.
Well, I wouldn't say that I'm shy about that. I think economics is extremely important and extremely beneficial to any form of legal analysis. But it's not the only way to get there.
Mm-hmm.
It's not the only route by any stretch of the imagination.
That would be a comfort to many, if not most, of the people who see your interview.
But you've been very kind in your comments.
Vaughn, we have a few minutes left. If there's something that we haven't covered that you'd like to discuss, this is a good time.
Well, I think one of the challenging and interesting aspects of antitrust practice going forward is the internationalization of antitrust enforcement. And that, of course, is a product of the internationalization of business and economics generally. We no longer operate in an economy that is bounded by the boundaries of the United States of America or even by North America. It truly is a worldwide economy. I'm not sure that we've entirely absorbed the full impact of that in our thinking on antitrust or in many other areas as well. With the overlapping jurisdictions, with the obvious local preferences that various markets exhibit and political authorities exhibit, is going to make antitrust and competition enforcement ever more challenging. And all of this is occurring at a time when the world is moving to a system in which lots of doors are opening throughout the world. We're seeing this at the present time in the Middle East in a political sense, but we're going to see that more and more in an economic sense as well. The world economy is increasingly integrated, and that's going to make the proper enforcement of competition standards highly important and much more challenging and much more interesting.
You mentioned in the Oracle opinion the relevance, well, in that case, of the global market, contrary to what the government was arguing, saying you couldn't really disregard SAP Germany from in thinking about SAP America. But you also mentioned that after your decision, the European Commission reached a similar conclusion on the transaction. Had it gone the other way, your trial would have all been for naught. And I wonder whether the global situation you've just described doesn't really mean that there are a large number of veto parties out there, any one of whom, or any one of which can frustrate what would otherwise, or what everyone else thinks is an efficient transaction.
Well, absolutely, and that's one of the great challenges that we face at the present time. The challenge is to attempt to make the best informed, most knowledgeable regulatory body the one that has primacy in the enforcement process. That requires a good deal of deference between jurisdictions, between agencies, between enforcement bodies that are often subject to very considerable political pressures. And that reaches beyond economics and makes competition law on a worldwide basis very complicated, very interesting, very challenging.
Quite a change in that respect from asphalt markets.
It certainly is, and quite a change from the antitrust regime or framework that we grew up with, where we thought all roads led to the Department of Justice Antitrust Division. Of course, we see this on a somewhat micro basis here in this country, where state attorneys general are increasingly involved in antitrust enforcement, and even local bodies. So the framework in which competition issues play out today is very much of a mosaic and an increasingly complicated one.
I don't think anyone will disagree with you on that. It's going to be quite a challenge. Thank you so much for your time and your thoughts on this.
Thank you
subject.
for
Appreciate
the
it.
questions,
Vaughn,
Doug.
no pleasure.
You bet.